Law matters. Of course it does. Welcome once again. My name is Debbie Moraes, your host and moderator. This long-running program continues to provide legal information, practical examples, practical assistance to help you with the law matters, because the law matters. A better understanding of the law puts you in a better position to understand how to best protect yourself, your family, and your business. As we present various topics, you may decide to enlist professional counsel. You may decide to handle some issues yourself. Either way, our goal is to help you to achieve the best possible results while saving time and money, and we try to help you prepare to do this. As always, we want to welcome and thank Attorney David Bizarre from the Bizarre and Associates law firm in East Providence, who continues to weigh in on all of our topics. So today, the juvenile justice system. It's safe to say the goals of America's juvenile justice system are to keep citizens safe and to rehabilitate the delinquent youth. Unfortunately, we know that doesn't always happen. Sometimes there are complaints about lack of funding or that policymakers aren't always able to institute or establish the programs that they need to achieve these goals. We often read those things. I think often it's cited that the biggest problem is that they're facing punishment rather than rehabilitation. So certainly that's something we're going to talk about today. The good news is that while juvenile crime rates rise, they also fall, and there is good news. Reported in 2021, there is a 75% decline since 1996, and when breaking down that number in different crime types, the figures look even better, more promising. Violent offenses have seen the most significant drop since somewhere in the mid-90s, and that would mean the murder and rapes and robberies and aggravated assaults. So that's a good trend. So to start our conversation, knowing that there's a difference between how juveniles and adults should be handled and are handled, let's start with a primer. David, tell us about the juvenile justice system, how it works, and what some of the issues are with it, and what we can do about it.
So as you said, the goal is very different in a juvenile system as opposed to the adult system for criminal kind of cases, in that the adult system is designed to punish people, and it's a deterrent theoretically for other people acting incorrectly, and that's the goal of the adult system, is to punish and deter, as opposed to the juvenile system, which is to reform or rehabilitate. And the idea is that there's good in everyone, and we need to find a way to get to the good and deliver services that will help rehabilitate somebody so that they don't follow a path into adulthood where they would be committing crimes and living a life that isn't what we want people to live.
That's a positive inclination. That's a good perspective from under which to operate.
Right, and so that's the whole idea of that system. And as you said, it doesn't always get to that result, but that's the goal. And since the goal is to rehabilitate, because as I said, we believe there's good in everybody, there are those cases that come along where there is no good, and it doesn't seem like there is anything that can be rehabilitated. And the system has been designed in those circumstances to waive that child out of the juvenile system and into the adult system. And that really was sort of codified after that Craig Price situation in Warwick, where the young man killed not one person, but several people. And there was no law at the time on the books to waive somebody out at the age that he committed those crimes, having not been charged and convicted of having done any other crimes prior to that age when he could have been waived out of family court. So they changed the rules so that if the crime is so heinous that you can get waived out really almost at any age, depending on the circumstances. Obviously, there's a limit, but the judge can take into consideration the facts of the case and the age of the person.
And so is that usually the case in other states? You're speaking of what happened in Rhode Island. There are other cases across other states. Is that done on a state-by-state basis that prompts then a law to be passed, or does that even need a law? You just decide and waive it when they need to, and charge them as an adult when they need to do that as well?
It is on a state-by-state basis. Juvenile law generally is specific to each state, so state-specific laws require you to follow the rules of each state. As a charge or crime has been committed by a juvenile, what they will face will be specific to the rules of that particular state.
In general, is it 18? That's the
So
youth?
that's an interesting question. So that was the law
Yeah.
for many years. And then, I don't know if you remember this or not, but in Rhode Island, they actually changed it to 17. And then the idea was that people who were 17 were being charged as adults and could have been charged as adults. And then they came to the conclusion, well, this is a really bad idea. And they changed it back to 18. But what happened to those folks who were caught in between, charged at 17, when you could be charged at 17 are now 18, how do we handle those cases? And so it became an interesting situation as to what to do. But generally speaking, 18. However, just so to throw something in on that, the punishments that can be given, which we don't give punishments, the rehabilitation that we can invoke can go beyond 18 to 21.
And what are the kinds of crimes that typically are juveniles are charged with? I mentioned earlier that there's a decline in the rapes and the murders and the violent assaults, but there are things called status. Are they crimes or are they status offenses? What's our juvenile crimes?
So a juvenile can be charged with any of the crimes that are on the books for an adult. There are also other things that a juvenile can be charged with. Of course, there's always truancy and those types of things. This is what the court in Rhode Island tries to do. And each city and town also has an ability to handle these types of situations on their own. Many towns have what's called a juvenile hearing board, where the police don't refer the case to state court for prosecution, but rather try to handle minor things, simple things within the town of itself. I don't think every town has that, but most or many do. And so juvenile hearing board is appointed by the city or town council or mayor, if the mayor has the authority to appoint, and they hear those cases and make recommendations of many different types of things. It could be community service, it could be whatever kind of individualized program that board thinks would be helpful to put a child on a good path and not go down a bad path.
What you're mentioning actually is a good place or a springboard from what I wanted to speak about. You're talking about them having some discretion, some flexibility. So let's talk about the similarities and differences in the adult crime and juvenile offenses and the system as it is. How do they compare or how do they contrast, David?
Well, again, the adult system is designed to punish and protect society and deter others from committing crimes. So on the protection side of society, when somebody commits a crime, and it depends on the level of the crime they commit, there's a system to set bail. And the bail is designed to make sure that the adult criminal, or alleged criminal, returns to court for their hearings, but also perhaps designed to protect either individuals in general or the society in general from further harm. So you'll often talk about or hear about domestic violent cases where there's a charge of someone being charged with domestic abuse or domestic assault. And as part of their bail, there'll be a no contact order. You can't contact the victim and that type of thing. Or it could be a more serious charge where the bail is either set at a very high amount, or if you have a murder or capital offense type of case, no bail at all, held without bail. And you're held until your case goes through the system. Again, they look at what is the ties to the community to determine whether or not someone will return to court, and also what do we have to do based on the severity of the charge to protect people from something else happening.
How does that impact on a child then? If you have a minor, bail, no bail, who's responsible for it? Does a parent have to kick in?
So I was going to go to the difference in the juvenile system. It's oftentimes, depends again, not every time, because there could be something so serious that and in Rhode Island, the family court judge, who has jurisdiction over those juvenile cases, for the most part, will want to hold someone at the training school. doesn't happen a lot, and it depends on how many times someone has been before the court and what types of charges and that type of thing. Oftentimes, the child's released to the parent's custody, and rules can be set in place, such as a curfew or other conditions that the court thinks are needed and reasonable, and always with the promise that you're going to listen to the lawful orders, so to speak, of the parent, that the child will agree to whatever restrictions the parent puts in place, as well as whatever the court puts in place.
And if a child is in the system, the government system, is the government the parent? As that, there's a Latin word for that I can't quite recall, but then is that child sent back to a DCYF placement, if that's what it is? How does that work if the child is not with his or her parent?
Right. So when a child is held at the training school, the child is put in the custody of DCYF. And that's similar to, it's not like the DCYF cases where a parent is bad and they take the child from the parent and then they put him in foster care. They're holding the child in detention at the training school. And DCYF is in charge of that, and therefore the child's in the custody of DCYF. So that's an order that actually will be made if a child's going to be held at the training school.
And when an adult commits a crime, they're going to a judge, maybe a jury. When it's a child, judge, no jury. What are the differences?
Yeah, so a couple of things I wanted to get to as we get into that system, but we talked about that cities and towns have a process to keep the child from going through the court system. The court actually has a process to keep the child from going through the court system and appearing in front of a judge. And it's sort of like a diversion program. In adult cases, there's a diversion program where if you've not been charged with a very serious crime, but there are some issues that need to be taken care of, and but the Attorney General can decide, rather than sending you to court, we're going to put you in diversion, which is an ability to have your case resolved. You do certain things. Maybe there's a little restitution that needs to be made. Maybe there's some drug or alcohol rehab that needs to be done. And you go through that process, you complete the process, and then the case is dismissed. In the juvenile situation, the court can refer you to a program, an intake program, where you meet with someone that works for the court. They go through this situation, look at it, and say, yeah, it's not so serious that we need to put you in front of a judge, but here are some things we want you to do. Here are the steps we want you to take. And the child, the parent, and the court sign a contract. And you agree to follow the rules of the contract, complete the things that are set forth in the contract, and at the end of the day, it's not referred in front of a family court judge. Now, if it is referred to a family court judge, then the process would be that you have that arraignment, or where you're either released to your parents or not, usually are, and then it's set for pre-trials with an attorney general to pre-try it with your attorney, private attorney, or public defender, or whoever is representing the child. And if you work something out, just like in the adult system, it goes in front of the judge approves whatever the agreement is, and you go from there. If it's not worked out, the difference, as you said, the bigger difference is, for the most part, there are no jury trials in juvenile cases. You don't have a right to a jury trial. So therefore, your case is heard. And here's part of the reasoning for that. The goal isn't to incarcerate and punish you, it's to rehabilitate you. And that's the rationale for not being entitled to a jury trial in the first instance in the family court.
Is it always true, sometimes true, that when a child is arrested, he may or may not end up having to deal with a judge? Maybe they might dismiss it. Does that happen at times too? Could a police officer say, kid, don't do it anymore, or I'll put you in a bad place here,
Yeah.
you're going to be in a problem. But otherwise, you get off scot-free for once. Do they get a get out of jail free card various times?
That's possible.
It
There's
is possible.
prosecutorial discretion, but more likely that's where the police department, usually with the juvenile officer, will say, yeah, we don't really need to send you to a judge. We're going to refer you to that intake center. Or if they have a juvenile board, to the juvenile board, or we'll handle it internally.
And if there's a problem with a child, I would imagine if you have a jury, then that means 12 more people could know about what was going on. Aren't records sealed, possibly expunged, cleared?
Yeah.
And the fewer people who see or know, the more protected that child is from that news spreading. Is that a factor at all?
Well, I don't think it's a factor in the reason we don't have juries, but certainly what you're saying is correct, that juvenile records are held under seal, that there's confidentiality. In fact, many times when a juvenile is in front of a judge, they even sometimes ask lawyers to leave the courtroom, which I don't know that they really should do or can do, because there's a reason lawyers are generally in there. I'm talking about lawyers who aren't directly connected to the case.
Oh, okay.
But
okay.
There's other reasons why a lawyer might be in there, not just because of that case, but a young lawyer, I think it's important to let a young lawyer sit through cases to learn how the process works. So they should be allowed to sit through even if it's not their particular case. But the judges do very much respect the confidentiality of juvenile process, and it is really usually limited to just those people who need to be in there, and the public is no right to be in there.
Okay. When you talk about the youth seeing a judge understands law. A judge may be given information about or context about that child, I imagine, especially if he or she is represented by a lawyer. Help us understand the impact on the youth. So before the crime or alleged crime happened, maybe he was with a bad gang, maybe the person was under the influence, maybe the person was on drugs or experimenting or habitual, I don't know, any combination of those. Does a judge get that information, factor that information in? Does that feed into his decision as to how that child will be rehabilitated? How does that work, David?
It's a really good question. And I had a situation once. We had Law Day, and part of the Law Day that I participated in was I went to a inner city school in Providence, younger kids really, not high school, and I was with a family court judge who was in charge of what then was a pretty new calendar for drug calendar for youth. And it was really designed not to put the child through the juvenile system, but rather to get them rehabilitation and whatever help they needed not to have the drug situation. And one of the kids raised their hand and they said, the child comes out of their home and goes through whatever process or rehabilitation center or wherever you send them. You think you've helped them and they're no longer drug dependent. And then you send them back to the same environment that they were in. And the young lady asked the judge, do you think you really changed anything? And the judge sat back and she said, you're right. We have to spend more time digging in not only into the child's issues, but the family's issues. And I think the court has taken the time and as much resources as they can put into it to try to look into those situations.
So when I think about costs, financial costs, emotional costs, you say the idea is to rehabilitate, not to incarcerate or put a child away. If a child is confined or put into the system, even if they're with other kids and not with adults, which presents myriad other issues that I don't want to discuss, if they're put in a situation with other troubled youth, there's the actual financial costs, the per body, per head, per meal, but also the cost long-term of additional, maybe unnecessary damage to that child just being in that environment. And it speaks a little bit to what you were saying about the child going back to the family environment, but any environment in which it could foster more trouble rather than help.
Yeah,
What goes on now to
that's
help
always
that?
been a concern, that when you take someone who is being rehabilitated, which is there any rehabilitation through the training school that's effective?
That's the question.
And what they really might be doing is being educated by other people who have more experience in doing bad things,
Worse things.
in having that influence, as opposed to being in another facility where there's more ability to help the actual underlying problem that may have caused the bad behavior in the first place. And it's something that we should always look at and consider and try to refine and improve how you deliver services to young folks who can be helped and rehabilitated, rather than, as you said, we won't get into the whole idea of locking a young child up who's now being treated as an adult in the ACI and what that may do with real bad influence, but even trying to make it as much of a rehabilitation as it's supposed to be as it can be.
And speaking to the financial cost, I can't remember exactly, but somewhere around 2019, 2020, I saw a figure of $215,000 to securely confine that child. My goodness, what could $215,000 actually do to benefit the child? Never mind incarcerate them in a place which is a less than ideal environment. Yeah. What are the child's rights? I know that they have a right to an attorney, right to face their accused, right to representation's an attorney, I guess. Yeah. Right to
confront and cross-examine the witnesses that are being presented against them, the right to present their own defense, to testify on their own behalf if they choose to, but they don't have to because they do have a Fifth Amendment right against self-incrimination. They have all of the same rights as any adult charged with a crime.
Thank you, Counselor. Do they also have the right, if they're underage, to have an education, to have health care? You could get quite a good education for $215,000 a year, I'm thinking.
Yeah, so absolutely. And there is a requirement of whatever place, training school, rehab facility, wherever you are, to make sure that the child is receiving an education at the same time that they're receiving whatever other treatment and benefits that they need to rehabilitate them.
And always you worry about them falling backwards or recidivism, repeat offenses. Not surprisingly, though I can't cite the statistics, the child who's well educated has less likelihood of falling into those circumstances that could get him into trouble again. I can remember speaking to the head of a prison that took care of both adults and young people who were incarcerated, and their job was to keep them confined, not to find them a job, not to give them voc ed, and not to educate them. What do you do about recidivism? What can you possibly do about recidivism, especially if they're incarcerated?
Yeah, so what you were talking about is give somebody a skill, give them some education, some training, give them an opportunity that when they're no longer incarcerated and they're out, that they can find something, some passion that they have to be able to pursue it with some background or foundation that you've helped give them through education.
Do you know anything, what do you know about the recidivism rates in Rhode Island, in Massachusetts, nationally? What are trends like these days?
So I don't know the rates, but I do know that the more you treat a child as a criminal, the higher the recidivism rate's going to be. And it's just a matter of logic, because you haven't done anything to rehabilitate and give them the skills that they need to find a way to make their life meaningful and useful.
Of course, very recent elections, I believe it is the new governor of Maryland, had reported out that he had, as a black youth, been in trouble, been incarcerated also is a Rhodes Scholar, very accomplished, incredibly articulate, and certainly, you talk about rehabilitated, certainly there's someone who's been able to turn life around, and there is news that it can happen. We wish it happened more frequently. When you think about trends in the court systems that are always bogged down right now, does that bode well for a young person who's confronting the system for the first time? Is it more likely that they will have been met with some leniency just because there's so much to deal with? If he didn't do that bad of a crime or an alleged crime, if it's truancy and curfew violation or whatever, he's not going to end up being part of a system. Is that likely to happen now?
So I don't think the backlog should be the reason for that to
Right.
happen. The reason for it to happen is because it's not about punishment, it's about rehabilitation. And so every case should be looked at of a young offender who hasn't done anything wrong before, who is just starting down the wrong path and hasn't done something so bad. What is it that caused you to go down that path, and what can we do to help you not to do that in the future? It's about rehabilitation.
Are there advocates that are assigned ever to the youth to check in on how he's doing, what she's doing 1 month out, 6 months out, to make sure that he isn't borderline or over the line?
There is the ability of, if it's going through the court, for the court. And as I said, when you resolve a case at pretrial, before it gets to trial, for the people who are putting together a plan, to put together a plan so that there is someone overseeing it and making sure that you're doing the right thing. And whoever's doing that should be doing it from almost like a counseling point of view, as well as a review for the court or the Attorney General's office or whoever they're reporting to.
Okay, and in the short amount of time we have left, give us the parents and the child who is facing an accusation in court. Give us some tips and information about how he, she could best plead his case, or at least make a good presentation of his case.
Well, the interesting thing would be, from a lawyer's perspective, who's your client, the parent or the child? It's the child, so you're really representing the child and the child's best interest. But oftentimes that does go parallel with what the parents want, but it doesn't always. So there's an interesting line that a lawyer has to walk in representing a juvenile, but also the parents need to figure out what their role is in all of this and how they can help and what they should be doing. And as a lawyer for the juvenile, I'm also looking at, are the parents helping or hurting in this particular case? Not what is going to be the least criminal type of charge or punishment, but what is going to be the best resolution to get my client, the child, in the best place.
Good to know. Let's hope that we don't have too many of these issues to deal with, but we hope that if you have had to grapple with the situation, that our addressing the juvenile justice system has been helpful to you. We ask that you stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.